You land at JFK, you join the line, you hand over your passport and green card, and the officer looks up and says one sentence that makes your stomach drop. Step aside. In your head, you hear the rumor you saw on WhatsApp 3 nights ago. Green card holders are frozen. They're not letting people back in. 90-day crackdown. Everyone from these countries is being denied. Your hands start to sweat because you don't know what's real anymore. And that confusion is exactly the point. Because the most dangerous thing in immigration policy right now is not the headline. It's the gap between what the law actually says and what you think it says. That gap is where families make the devastating mistake, canceling travel that was safe, traveling when it was high risk, abandoning applications they shouldn't abandon, or signing documents at the border they don't understand. This is Immigration News Desk. And today I'm going to cut through the panic with verified structure. What the December 16, 2025 presidential proclamation actually does, who it actually targets, why green card holders are explicitly exempt from the travel restrictions that took effect January 1, 2026, and what's still changed underneath that exemption. Because yes, you can be exempt and still be pulled into a bureaucratic trap. Stay with me until the end, because I'm going to give you the exact checklist you should follow before you travel. And I'm going to explain the one moment at the airport where lawful permanent residents lose their status. Not because they were deported, but because they were pressured into voluntary surrender. If you understand that moment, you stop being easy prey. Let's establish the hard fact first, because it's the center of the confusion. There is no travel freeze for green card holders under the January 1, 2026 travel restrictions. If you are a lawful permanent resident, meaning you hold a valid green card, you are explicitly exempt from the entry suspensions in the proclamation, regardless of your nationality. That is not my opinion. That is the structure of the proclamation, as it has been described and analyzed, and it has been repeatedly confirmed by legal analyses pointing to the text itself. But here's the problem. People hear travel ban, then they see USCIS pause, then they hear 90 days, then they see biometrics, and their brain compresses everything into one terrifying sentence. They're coming for everyone. That compression is misinformation's greatest weapon. So we're going to deconstruct this carefully because you don't need fear. You need operational clarity. On December 16, 2025, President Trump issued Presidential Proclamation 10998, described as restricting and limiting the entry of foreign nationals to protect the security of the United States. According to the policy timeline described in your source, it took effect at 12:01 a.m. Eastern on January 1, 2026. This proclamation expands restrictions to nationals of 39 countries, plus individuals traveling on Palestinian Authority-issued travel documents. You need to understand what kind of tool a proclamation is. It is not Congress rewriting immigration law line by line. It's an executive mechanism, usually grounded in Section 212F of the Immigration and Nationality Act, that allows the president to suspend entry of certain classes of non-citizens if their entry is deemed detrimental to U.S. interests. This authority has been used before, aggressively, and it's the same legal backbone behind the 2017-era travel restrictions that ultimately reached the Supreme Court. And this is where the history matters, because it tells you how this will behave over time. The 2017 travel ban didn't arrive as one clean, stable rule. It arrived as a sequence: initial order, chaotic rollout, court injunctions, revisions, new versions, litigation, and finally, a Supreme Court decision that gave the executive branch wide latitude under 212F. That precedent matters because it means once a proclamation is issued, it can be fought, but it can also survive, especially when it's framed as national security. You should assume it will remain in play until modified by the administration, constrained by courts, or politically reversed. Now, the proclamation described here creates 2 tiers. First, full suspension for 19 countries, meaning both immigrant and non-immigrant visa issuance is suspended. The list as described includes Afghanistan, Burkina Faso, Burma, Chad, Republic of the Congo, Equatorial Guinea, Eritrea, Haiti, Iran, Laos, Libya, Mali, Niger, Sierra Leone, Somalia, South Sudan, Sudan, Syria, and Yemen, plus Palestinian Authority travel documents. Second, partial suspension for 20 additional countries, meaning immigrant visas are suspended, and certain non-immigrant categories are restricted, specifically categories like B1, B2 for visitors, FM for students, and J for exchange visitors, as described. The exact list of those 20 countries in your source includes Angola, Antigua and Barbuda, Benin, Burundi, Côte d'Ivoire, Cuba, Dominica, Gabon, the Gambia, Malawi, Mauritania, Nigeria, Rwanda, São Tomé and Príncipe, Senegal, Tanzania, Togo, Uganda, Venezuela, and Zambia, with Turkmenistan described as having immigrant restrictions and more limited non-immigrant restrictions. Now we get to the first critical precision point, because this is where panic spreads fastest. Who is actually affected by the entry restrictions? As described, the proclamation applies to nationals of the impacted countries who were outside the United States on January 1, 2026, and did not hold a valid visa on that date. And your source also states something crucial. Visas issued before January 1, 2026 at 12:01 a.m. Eastern were not revoked pursuant to the proclamation. That means if someone had a valid visa already issued before the effective time, the proclamation itself does not automatically cancel it. This is not the same as saying travel will be easy. Valid visa holders can still face screening. Airlines can still deny boarding if they misunderstand guidance. Ports of entry can still question. But the legal concept matters. Not revoked is not the same as no longer usable. Now I'm going to open a loop that we're going to close later, because this is where people destroy their own cases. Having a valid visa or being exempt does not protect you from making a self-inflicted mistake at the border. Later, I'll explain exactly what to do if you are pressured to sign anything or agree to abandon status, because exemption doesn't stop an officer from offering you a shortcut that ruins you. Now let's talk about the part everyone came for, the green card exemption. The proclamation explicitly exempts lawful permanent residents. That means if you have a green card, you can travel outside the U.S. and return, even if you are a national of one of the restricted countries. There is no proclamation-based travel freeze on green card holders. So why are people still panicking? Because there are two other moving parts happening at the same time that sound like travel restrictions even when they're not. The first is a USCIS processing pause described in your source. This is separate from the proclamation. USCIS, according to a memo referenced in the source, paused reviewing certain pending applications for green cards, citizenship, or asylum for nationals from certain countries connected to the earlier June 2025 travel restrictions, and extended this enhanced review posture to newly added countries. This is not a travel ban. It's a benefits adjudication pause or slowdown, an internal processing posture that means applications can be held for enhanced vetting, re-interviews, re-reviews, and extended timelines. Here's why this matters. If you are already a green card holder, the processing pause is not about you re-entering. It's about you trying to obtain a new benefit, citizenship, removal of conditions, certain renewals, or family petitions that require adjudication. If you are waiting for a green card, the processing pause can feel like a wall because you are stuck in administrative limbo without a denial you can cleanly appeal. And here's the asymmetry. Travel bans are visible. Processing pauses are quiet. A travel ban tells you no. A processing pause tells you pending, and people can sit in pending for months or years without understanding what triggered the slowdown. That's why I call it a bureaucratic trap. It doesn't need to reject you to damage you. It just needs to stall your life. The second moving part is biometrics. Starting December 26, 2025, a new biometric entry-exit requirement is described as going into effect, collecting biometric data such as photographs and fingerprints at entry and exit points for non-citizens, including lawful permanent residents. This again is not a travel ban, but it changes the border experience and increases the government's ability to track travel history with precision. When you layer biometrics onto an enforcement-heavy climate, the fear becomes, are they building a file on me? The honest answer is, they are building a travel record on everyone covered by the system. and travel records can be used for ordinary identity verification or for enhanced scrutiny if something else triggers attention, like long absences, inconsistent addresses, unresolved warrants, name matches, or, in rare cases, alleged abandonment of residency. Now, the most dangerous misunderstanding in immigrant communities right now is that these three things are the same. They're not. Proclamation-based entry restrictions target new visa issuance, and entry for certain nationals outside the U.S. benefits processing pauses target pending applications inside USCIS. Biometric requirements target border verification for non-citizens. If you collapse them into one story, you will make bad decisions. Let's break down what this means for different people, because this is where you need to locate yourself in the system. If you are a current green card holder, your travel rights have not been frozen by the proclamation. You can continue traveling and returning, but you should assume more documentation, more scrutiny, and more data capture, especially if you are a national of one of the restricted countries. Enhanced screening is not the same as being barred. It's friction, it's longer questions, it's secondary inspection risk, and you reduce that risk by traveling prepared, not traveling nervous and empty-handed. If you are applying for a green card or citizenship and you are a national of a country caught in an enhanced review posture, your timeline may be affected. This does not automatically mean denial. It means your case can be held longer, requested for additional evidence, or sent into re-interview channels. And this is where the devastating mistake happens. People assume pause means rejected, and they stop responding, miss deadlines, or abandon the case. If you do that, you turn a policy slowdown into your own legal failure. If you are outside the U.S. and you need a new visa and you are a national of one of the 39 countries, the proclamation is the wall. New issuance is fully or partially suspended, depending on the category. Existing valid visas issued before the effective moment may still be used, according to the language described, but new issuance becomes extremely difficult or impossible, while restrictions remain in effect. If you are a dual national, this matters. A dual passport can change your risk profile. As described, dual nationals traveling on a passport from an unrestricted country can often avoid the restrictions tied to the restricted nationality. Example given: a Haitian-French dual national entering on the French passport. This can reduce the friction you face. But do not treat this as a magic cloak. Border systems still see your history. And if you have pending applications tied to your restricted nationality, that's a separate track. Now we need to talk about exemptions beyond green card holders because they reveal the administration's priorities. The proclamation includes exemptions for certain diplomats and government officials, athletes and support staff for major events like the 2026 World Cup and 2028 Olympics, certain special immigrant visa holders, and certain persecuted minorities. It also includes a waiver process, case-by-case, discretionary, national interest-based, at the Secretary of State's level, expected to be rare. This is not just policy detail, it's a message. The system creates doors for high-visibility events and national interest categories while closing doors for ordinary families. Which brings us to one of the most consequential changes noted in your source: the removal of prior exemptions for immediate relatives of U.S. citizens. Historically, even in restrictive eras, spouses, minor children, and parents of U.S. citizens often had carve-outs. The source indicates that the December 2025 proclamation eliminates those exemptions from the June 2025 framework. That means even if you are the spouse of a U.S. citizen, if you are outside the United States, a national of a restricted country, and you don't have a valid visa as of the effective date, you may be blocked unless you qualify for a waiver. This is where families are going to be emotionally destroyed, because the public assumes U.S. citizens can always bring immediate relatives. That is not guaranteed under executive restriction regimes. And if you are a green card holder watching this, understand the downstream effect. Your family-based petition may be approved by USCIS and still be trapped at the consular stage by proclamation-based restrictions. The system can approve the relationship and still block the entry. Now let's address the 90 days confusion, because this is the phrase that keeps getting weaponized online. The source references a USCIS memo stating that within 90 days, the agency would create a prioritized list of immigrants for review and, if necessary, referral to immigration enforcement or other law enforcement. That 90-day timeline is not a 90-day freeze on green card holder travel. It is described as a timeline for USCIS to build a prioritized review list for pending applications from restricted countries. If you merge that with the travel ban story, you create the rumor. In 90 days, they will start stopping green card holders. That rumor is not what the memo describes, but it will still cause harm because people will react to it. Cancel trips, quit jobs, withdraw applications, avoid necessary travel, or hide. And hiding is how you increase your vulnerability because it causes you to miss notices and deadlines. Here's the open loop we need to close now. What do you do at the airport or border if you are a lawful permanent resident and an officer starts pushing you toward abandonment language? You need to understand your rights. As a green card holder, you have the right to return to the United States. You also have due process rights. CBP can question you. CBP can inspect you. CBP can send you to secondary. But CBP cannot just take your green card by vibe. If an officer believes you abandoned residency, the law provides procedures. In many cases, the officer may suggest you sign a form relinquishing your status, commonly Form I-407, Record of Abandonment of Lawful Permanent Resident Status. If you sign that form, you are voluntarily giving up your green card. That is silent confiscation disguised as paperwork to make it easier. Do not sign anything you do not understand. If you are pressured, you can request to speak to an attorney, and you can refuse to sign. Refusing can escalate the situation, yes, and in extreme cases it can lead to removal proceedings before an immigration judge, but that is exactly the point of due process. A judge, not a border officer, determines your fate when the facts are disputed. So what protects you in the real world? Preparation and documentation. If you travel as a green card holder, especially if you are from a restricted country or you have long absences, you should carry proof that the United States is your primary home. Proof of residence, employment letters, recent pay stubs, tax filings, lease or mortgage, family ties. Not because you want to argue at the border, but because secondary inspection is a document-driven environment. The more coherent your narrative and evidence, the faster you exit the room. Now let's get practical with action steps, because information without action is just anxiety. If you are a current green card holder, first check your green card expiration. If it's expired or close to expiring, renew it. Second, make sure USCIS has your current address. Federal law requires address updates within 10 days of moving. Third, if you travel internationally, build a small travel folder with documents showing your ties to the U.S. Fourth. Expect biometrics collection and possible delays. Stay calm. Answer truthfully. Do not volunteer unnecessary details. And never sign away your status under pressure. If you have a pending green card or citizenship application and you are from a country subject to enhanced review or pause, monitor your USCIS account and mail relentlessly. Respond to RFEs on time. Do not assume you've been denied. A pause is an administrative state, not a final outcome. Consult an immigration attorney if your case is complex or if you receive confusing notices. If you are outside the U.S. from an affected country and you already hold a valid visa issued before the effective date, the proclamation language as described indicates it was not revoked on that basis, but you should still expect enhanced screening. If you need a new visa, understand issuance may be suspended for your category. Explore exemptions, dual nationality routes, and waiver possibilities only with professional guidance. Waivers are not DIY. And now, where do you get official information so you stop being manipulated by viral posts? Whitehouse.gov for the proclamation text. Travel.state.gov for State Department visa guidance. USCIS.gov for policy memos and processing guidance. CBP.gov for entry procedures. And for interpretation, reputable immigration law firm alerts and organizations like the American Immigration Lawyers Association. This is how you anchor yourself in reality when rumor tries to hijack your decisions. Now let's talk about why this legal framework is so powerful, because you need to understand the architecture to predict behavior. Section 212F of the INA gives the President wide authority to restrict entry. Courts have historically been reluctant to second-guess national security framing, especially after the Supreme Court upheld a version of the earlier travel restrictions. That means the current proclamation is designed to be legally resilient. It also includes periodic reviews every 180 days, which means the list and terms can change. That creates rolling uncertainty. And rolling uncertainty is not a side effect. It is part of the pressure system. Here is the reality you need to internalize. Immigration policy in 2026 is not stable. It is iterative. It is reactive. It is litigated. It is reissued. And it is implemented unevenly at airports, consulates, and field offices. Your safety comes from accurate information, documentation, and refusing to make irreversible moves based on incomplete stories. So let's summarize the truth, cleanly, so you can repeat it to anyone panicking in your community. There is no travel freeze for green card holders under the January 1st, 2026 proclamation-based travel restrictions. Lawful permanent residents are explicitly exempt and can continue to travel and return. But there are significant restrictions affecting nationals of 39 countries seeking new visas or entry. There is a separate USCIS processing pause or enhanced review posture affecting certain pending benefit applications for nationals of certain countries. And there are new biometric entry, exit, and screening requirements that apply to non-citizens, including green card holders. Exempt does not mean frictionless. Exempt means you're not barred. You still need to travel smart. If this video saved you from misinformation, share it, because rumor is contagious and the cost of rumor is real. And if you want verified, fast updates as these policies evolve, subscribe here at Immigration News Desk. We'll keep translating proclamations, memos, and border procedures into what they actually mean for your life before you find out the hard way at a port of entry. And remember the final rule of survival in a tightening system. Don't let panic make decisions for you. Let documents, official text, and qualified legal advice do that.